Most Americans favor equality in the abstract, but the concrete struggle for equal rights has been our nation's most bitter battle. The real meaning of equality is both elusive and divisive in this country. Civil rights are the policies that extend basic rights to groups historically subject to discrimination. The modern civil rights movement began in 1955 when Rosa Parks refused to give up her seat in the front of a Montgomery, Alabama bus. Today's debates over inequality in America center on racial discrimination, gender discrimination, and factors such as discrimination based on age, disability, and sexual preference. Philosophically, the struggle for equality involves defining the term. Constitutionally, it involves interpreting laws, and politically, it involves power. Jefferson's statement in the Declaration of Independence that all men are created equal did not mean that he thought there were no differences among people. American society does not emphasize equal rights or equal rewards. A belief in equal rights has often led to a belief in equality of opportunity. When it comes to the Constitution and inequality, few colonists were eager to defend slavery. And the delegates to the Constitutional Convention did their best to avoid facing the divergence between slavery and the principles of the Declaration of Independence. Women's rights received even less attention than did slavery at the convention. And the delegates to the Constitutional Convention came up with a plan for government, not guarantees of individual rights. The word equality does not even appear in the original Constitution. Even the Bill of Rights does not directly mention equality, but it does have implications for the principle of equality since it does not limit the scope of its guarantee to any specified groups. The only place in which the idea of equality clearly appears in the Constitution is in the 14th Amendment, which prohibits the states from denying equal protection of the laws to any person. What does equal protection of the laws even mean? It was not until the mid-20th century that the 14th Amendment was used to assure rights for disadvantaged groups. Over the last 100 years, the Equal Protection Clause has become the vehicle for more expansive constitutional interpretations. The court has developed 3 levels of judicial scrutiny. The 3 levels of judicial scrutiny or classifications are the following. Most classifications that are reasonable, meaning that bear a rational relationship to some legitimate governmental purpose, are constitutional. Racial and ethnic classifications are inherently suspect. They are presumed to be invalid and are upheld only if they serve a compelling public interest that cannot be accomplished in some other way. And the third, classifications based on gender fit somewhere between reasonable and inherently suspect. Gender classifications must bear a substantial relationship to an important legislative purpose, and you can see these 3 standards of review that the Supreme Court uses in this chart right here. During the era of slavery, any public policy of the slave states or the federal government had to accommodate the property interests of slave owners. The most infamous statement in defense of slavery occurred in Dred Scott versus Sanford in 1857, in which Chief Justice Taney declared that an African-American man was a chattel and had no rights under a white man's government. Congress had no power to ban slavery in the Western Territories, thereby effectively invalidating the Missouri Compromise. The Union victory in the Civil War and the ratification of the 13th Amendment officially ended slavery. The era of Reconstruction and segregation then brings us to Jim Crow laws and Plessy versus Ferguson. After the Civil War ended, Congress imposed strict conditions on the former Confederate states before they could be readmitted to the Union. As soon as they regained power, white Southerners imposed a code of Jim Crow laws, or black codes, segregation laws that required African Americans to use separate facilities and school systems. Although not required by law, segregation was also common practice in the North. In the era of segregation, housing, schools, and jobs were, in one way or another, classified as white or colored. The Supreme Court provided constitutional justification for segregation in Plessy versus Ferguson when it held that segregation in public facilities was not unconstitutional as long as the facilities were substantially equal, a principle that was commonly referred to as the separate but equal doctrine, though subsequent decisions paid more attention to the separate than to the equal part. Some limited progress was made in the first half of the 20th century, including executive orders and court decisions. during the period leading up to the Civil Rights Movement, segregation was legally required in the South and sanctioned in the North. Brown versus the Board of Education marks the beginning of the era of civil rights. The Supreme Court used Brown to set aside its earlier precedent of Plessy versus Ferguson. In this landmark decision, the court held that school segregation was inherently unconstitutional because it violated the 14th Amendment's guarantee of equal protection. And in 1955, the court ordered lower courts to proceed with all deliberate speed to desegregate public schools. However, we know from our history classes, desegregation moved very slowly until the passage of the Civil Rights Act of 1964, which denied federal funds to segregated schools. In the chart that's shown, you can see the percentage of black students attending school with any whites in the southern states. Even though the Supreme Court handed down their decision for desegregation of all schools, desegregation in the South took a very, very slow pace. The Civil Rights Movement organized both African Americans and whites to end the policies and practices of segregation. The movement began in 1955 when Rosa Parks refused to give up her seat in the front of a Montgomery, Alabama bus where only whites were allowed to sit. Her arrest resulted in a boycott led by Reverend Martin Luther King Jr. Sit-ins, marches, and civil disobedience were key strategy of the Civil Rights Movement, which sought to establish equal opportunities in the political and economic sectors and to bring an end to policies that put up barriers against people because of race. In the 1950s and 1960s, we saw a marked increase in public policies designed to foster racial equality. The Civil Rights Act of 1964 made racial discrimination illegal in hotels, motels, restaurants, and other places of public accommodation. It also forbade many forms of job discrimination, and Congress cut off federal aid to schools that remained segregated. That is incredibly important to remember, that under the Civil Rights Act of 1964, any school that remained segregated would not receive federal funding from Congress. Desegregation proceeded slowly in the South, and some federal judges ordered the busing of students to achieve racially balanced schools. This was upheld in the Supreme Court landmark case, Swan versus Charlotte-Mecklenburg County Schools in 1970. According to voting rights, the early republic limited suffrage, or the legal right to vote. You already know that term, primarily to property holding white males. The 15th Amendment in 1870, though, guaranteed African Americans the right to vote, but full implementation did not occur for another century. States used various methods to circumvent the 15th Amendment. You learned these in APUSH. The grandfather clause was one, which exempted persons whose grandfathers were eligible to vote in 1860 from taking literacy tests in order to vote. The exemption obviously did not apply to grandchildren of slaves. Poll taxes were another. Small taxes that were levied on the right to vote. The taxes often fell due at a time of year when poor sharecroppers had the least amount of cash available. Pretty smart. White primaries were also created to circumvent the implementation of the 15th Amendment, which permitted political parties in the heavily Democratic South to exclude blacks from primary elections on the pretext that political parties and their primaries were private and not public institutions. This device deprived blacks of a voice in the primaries, where the real contest occurred. Many areas in the South employed voter registration tests, sometimes called your voter literacy tests, in a discriminatory manner. Some of the tests checked for an understanding of the Constitution. The Civil Rights Movement put suffrage high on its political agenda, and many barriers to African American voting fell during the 1960s. Poll taxes in federal elections were prohibited by the 24th Amendment in 1964. Think about that for a minute. A constitutional amendment, the 24th Amendment, prohibited poll taxes in federal elections. The Voting Rights Act of 1965 prohibited any government from using voting procedures that denied a person the vote on the basis of race or color. Federal election registrars were then sent to those areas that had long histories of discrimination and many African Americans were registered in Southern states as a direct result. The Voting Rights Act produced a major increase in the number of African Americans registered to vote in the Southern states and in the number of African Americans who held public office. This is a key example in public policy implementation. We're going to stop here, see the next lecture or part 2 of chapter 5 to hear the rest of the notes.